joining, but I'll just start with an introduction because our webinar is always recorded, so you'll be able, anyone that joins later will be able to catch up anyway. So welcome, my name is Charlotte Burton. I'm the marketing manager at the Centre for Commercial Law Studies at Queen Mary. You might have seen me before if you've joined some of our other webinars that we're hosting at CCLS, and today we're hosting a taster lecture on intellectual property law with my colleague Duncan here, who I will let himself introduce himself just shortly. How the session will run today is I will pass over to Duncan shortly and he will run a taster lecture for you. Please feel free to ask questions based on the topic in the Q&A or the chat function you've got here on Zoom. We haven't got any of the admissions team here today, so we ask that if you have any admissions questions, I will put our email address for the team into the chat here, so you can get in touch with them. I can help on very limited content on that. If there are questions that you have, you can ask, and I can try as best as possible, but I won't be directing any of them to Duncan, as he is an academic and doesn't have to worry about that kind of thing. But any topic related, IP related questions, please feel free to ask away, and we'll have a short Q&A section at the end where you can ask those questions. So I can see we've had a few more join in that time. So I think, Duncan, if you're happy, I'll kind of pass over to you.
Thank you, Charlotte. Hello, everybody. Nice to meet you all, and great to see you posting in the chat all these amazing places that you are at the moment. So just by way of introduction, I'm going to share my screen with you and show you a useful website. It's the website for our Queen Mary Intellectual Property Research Institute. So along with the LLM program, all the academics who work in different specialisms of the law are located for the purposes of our research in different institutes. So if you're interested in IP at Queen Mary, I really recommend, you can probably see at the top bar there, it's just the usual qmul.ac.uk address, and then /QMIPRI, and that stands for, of course, Queen Mary Intellectual Property Research Institute. That will not only show you the types of research the academics are doing, including this about COVID, which is what your taster lecture is going to be about in a minute, but also if you click the tab for people, you can see there's a picture of me there, and if I click on that, you can see all the faculty members. And the reason that I wanted to show you this was partly because Queen Mary has the largest faculty of IP full-time academics anywhere in Europe. So in a minute, I'm going to explain a little bit about the LLM modules available for the specialism. And the reason that we're able to offer so many different IP courses within the LLM is because we've got this amazing faculty of full-time members of staff. So now let me stop sharing my screen. So you got the address for that. It's the usual Queen Mary, or that's the members page. But if I go back to the main page, if you just type QMIPRI, or you can just do an internet search for that in a search engine and have a look at our amazing website. Okay, so if I stop sharing, and I will now get ready to share the slides with you about the overview of the specialism. So I'm going to share my screen.
I'll put that link in the chat for you, Duncan.
Thank you, Charlotte. That's great. There you go. So if I just go to full screen mode, this is now an overview of the different modules that you can take as part of the IP LLM specialism at Queen Mary. I'll explain some technical stuff about the number of credits that you need to get for the modules, etc. And also come back to this point that actually we've got the largest number of different types of intellectual property that you can study in different modules anywhere in Europe. Okay, so if you're attending this meeting, I'm presuming you know already what IP is, but it's instructive to remember that when we talk about patents and copyrights and trademarks, quite often at universities, they will have a single course which covers all these main types of intellectual property rights. And of course, in some countries, they still refer to industrial property. So industrial property are registered rights such as patents and trademarks, and then have a separate category of IP called copyright. But what we do at Queen Mary is we break down these different components into many, many different specialized courses. So we go much deeper and into much more detail on each of these topics, which of course allows us to have amazing discussions with students about patents on drugs and what happens to vaccines during the COVID pandemic, the smartphone wars, who owns the patents on the network technology like G4, G5 interconnectivity, of course, copyrights, and particularly relating to online infringement of music, art, etc. Trademarks relating to things like logos and signs. And in addition, we even have separate courses on what we call hybrid rights that are a kind of a mix of patents, copyrights, and trademarks, or a specialist to particular fields of technology. So GIs are geographical indications, such as the names of, cheese from France, or a wine from Germany, etc. Certain names are protected as geographical indications. Unfair competition also becomes important, because if you are the owner of an intellectual property right, this does not mean you can do whatever you want with it. So if you abuse your dominant position as the IP right holder, you could be found contrary to competition law by the competition enforcement agency in your territory. We also have specialist modules, and in fact, a specialized professor dealing only with design rights. So there's a separate type of registered design right in most major IP systems, database rights, even plant variety rights. And I was talking to my students recently about a big American company called Monsanto, who developed a new type of agricultural crop, which is drought resistant. So if it doesn't rain for many months, the plant doesn't die in the farmer's field. It just waits for the rain to start again. But of course, this is protected by something called a plant variety right, because of the innovation of this company in producing this new type of plant. So access to that is limited because you need to get a license from the company that owns the plant variety rights. So I'll come back in a minute to how these kind of themes in intellectual property are organized in our offering of modules. But just to get what I call the technical bit out of the way, you will know already that to obtain an LLM from Queen Mary, you need to accumulate 40 credits in total. So you need to pass enough modules or a dissertation to take you to a total of 180 credits. So in order to get a degree which is a specialism LLM in intellectual property, you need to take either you can take all the modules in intellectual property, or maybe you want to take some modules in banking or tax or arbitration, etc. And in that case, you need to take a minimum of 150 credits. So you could still take 30 credits from another module. Or you can do a dissertation. We have an optional dissertation for the intellectual property specialism. So it's not compulsory to do a dissertation. So this is basically the different possibilities which you'll have time to consider before you enroll for the LLM, about what modules do you want to take, what's going to be most useful for your career, what you're interested in, and how you create this kind of mix, which will come to a total of 180 credits. So essentially, our modules in IP specialism, either they are 30 credit modules, which means they will run for 11 weeks in one semester, or they are 15 credit modules, which means they will run for 5 weeks, so for half of a semester. And here is like if you like, a typology of the different types of modules to kind of explain them as easily as possible. So there are modules with like broad coverage. So my colleague, Professor Uma Suthersanan, teaches a module called Global IP Law, which deals with global problems of intellectual property. And one of the things that Queen Mary is most famous for in IP is the second thing on this list, what we call the international and comparative subjects in copyright, patents, trademarks, and unfair competition. Because what we do not do at Queen Mary, we do not teach the English law of intellectual property. We are an international university. I think all of my colleagues, all the full-time, there are 13 of us who are full-time professors. I think the other 12 are from countries outside the UK. So we're international faculty, and we teach international law to international students. Secondly, we then deal with what I called here industry-focused coverage, things like design law, business of film, IP and fashion, how to commercialize and make money from your intellectual property, for example, through licensing agreement, interactive entertainment law, which is like gaming, online gaming, IP in China, esports, life sciences, which I teach, creative industries, and then finally the specialist perspectives of things like animal law, media and culture, digital IP, and geographical indications. And we essentially divide up the modules as logically as we can into the 3 semesters. So semester 1 or semester A, you can see just an example. This was just a snapshot from the year we're just finishing of the different modules that you could choose in semester A. And these are, again, a mix of 30 credit and 15 credit modules. Modules in semester B, this was from January until March this year. And again, we offered a broad range of modules that the students can choose. And in module C, these are all 15 credit modules. So they're shorter because this is only a 5-week semester, which we're going to finish in the next weeks. And again, you see more specialists than in the early semesters of the term. So that's essentially what I wanted to show you in terms of the outline of the module. So I've already used 11 minutes of my time. And what I'm going to do next is share my screen with you again and give you a sample lecture. So let me get my slides ready. By the way, we've been we've been teaching on campus, so in person, for the whole of this academic year. And we've been teaching sort of in hybrid format. So for example, if any of the students need to self-isolate or are not able to attend, we've had this facility where the students can follow online as well. But myself and the other professors, we're physically in the classroom. So everything has been online after the problems of the previous years with the pandemic. Which brings me conveniently to the topic of the COVID-19 pandemic. And this is a real life lecture that I gave to my students enrolled for the module in the International Law of Patents and Related Rights. And what I mean by related rights are things like these plant variety protection rights that I gave an example of a minute ago, and also things like trade secrets and confidential information, where a company decides not to apply for a patent, but instead to keep the invention secret and confidential. So I'm going to give you a short taster lecture where I explain. Now, we hope the pandemic is reducing in its impact in the world. So what lessons can we learn for the European patent system, for example? Well, this is a very topical issue, because if you look at the dates at the top of the slide, you will see that starting on Sunday until yesterday, there was a World Trade Organization ministerial meeting taking place in Geneva in Switzerland. And as you'll be aware, the World Trade Organization is an international organization which was created and came into force in 1995 and administers trade in goods and services, but also through something called the TRIPS agreement, administers trade in intellectual property rights. And as you'll see as I go through these slides, one of the controversial topics for negotiation at the ministerial conference this week was whether, in response to the COVID-19 pandemic, WTO member countries should, in their national law and procedure, be allowed to temporarily set aside their obligations to have national laws which observe rights on patents and related rights. And this is something called the TRIPS waiver, and you probably have seen it in the media discussed as a very controversial topic. So having said that this meeting would finish yesterday on the 15th of June, you'll see already this is an announcement, a screenshot from the website, which explains that essentially they didn't reach agreement on the future of IP rights during the pandemic. So they have extended for another day the negotiations to find a solution to how countries should have to implement their IP laws during the pandemic, plus other trade issues about fishing and food shortages and agriculture. But IP vaccines and COVID vaccines is one of the most controversial topics being discussed right now today in Geneva. So let's go back and recall how and why this controversial issue of IP and patents came about. You will recall that on the 31st of December 2019, government officials in the Chinese city of Wuhan started to report unusual numbers of people who had visited the seafood wholesale market who were reporting symptoms of a new type of pneumonia that hadn't been recorded in hospitals before. And by January of 2020, the Wuhan outbreak came to be called COVID-19. And was designated by the World Health Organization as an international incident, and by March of 2020 was designated as a global pandemic. Well, very significant in the global response to the pandemic was a Chinese virologist, Professor Zhang, who went online and shared through the internet the genome sequencing for the COVID-19 virus, so that potential vaccine manufacturers around the world could see that spike protein, like the crown shape with the little spikes of COVID that we're now so familiar with. So he was really a hero of this story because he went ahead and shared this information online so that researchers could start to develop vaccines and speed up the process, because they actually knew what COVID-19 looked like. Of course, at that time, the outbreak was only within China, so they needed to get hold of samples of the genome sequencing. So the race to find a vaccine then gained pace, and you'll remember through spring, well, in England, spring, so around March and April 2020, we began to see media stories that German company BioNTech, who later partnered with the American company Pfizer, Moderna, AstraZeneca, partnering with Oxford University and others, started to develop vaccines for COVID-19. And the controversy that I'm going to describe that relates to patents is, of course, that the patent system is designed to incentivize expensive research and development so that these type of companies will have an economic incentive to produce and research new vaccines or other types of technologies. And the patent right gives the owner of these technologies the right to exclude others without their consent from making, using, selling, importing, or keeping the patented product. So coming back to the WTO, the big question is, will a decision today on the 16th of June help to make available the patents by removing the obligation for particularly developing countries in Africa, Southeast Asia, Latin America? If you remove the obligation of governments to enforce the IP rights of these vaccine manufacturers, will it enable local companies, for example, in South Africa or Thailand or Bangladesh, to make their own cheap versions of the vaccines and to make them available to their local populations in the public interest? And if we do that, do we then undermine the whole purpose of the patent system, which is to incentivize further research? So the developing countries would like to see this, but the vaccine manufacturers are saying, but wait, if you do this, we will never have an incentive to invent a new drug ever again, because our patent rights will be undermined and ultimately our profits will be taken away. So just to show you a couple of graphics to show you the extent of, in a way, how successful the vaccine response has been. By the end of last year, 12.5 billion COVID vaccines had been manufactured. So this is a major success of the patent system. You could argue that the patent system incentivized this, it was compared to landing a human being on the moon, the speed in which highly effective vaccines were manufactured by multiple biotech companies. So it was a huge success and achievement for the world. However, that is not to take away from the fact that the scale of the pandemic has led to tragic deaths of more than 6 million people. These figures, I was checking in April. And so despite the fact that most of the vaccine manufactured had been administered, of course, the problem is that the vaccines were predominantly in the rich, developed countries in Europe and North America in particular, and that the poorer developing countries in the global south were still awaiting the delivery of vaccines, and because of IP rights, could not manufacture their own version of the drug without infringing IP rights. So this has led to something which is called vaccine inequality. And here you can see from selected countries, see I've chosen the United Kingdom, Israel, and France, where this is even from a snapshot from September last year. And this is for the whole population, including babies. So if you were to take out the infants, you would probably find that, I know in the UK, it's something close to 90% of the population have received at least one dose of a vaccine. And compare this to some West African and Central African countries where there are still less than 1% of the population have received the vaccines. So it's this vaccine inequality which has led to calls for this so-called IP waiver, so that countries would be free to manufacture their own version of these technologies. So why is it that countries have to enforce patent rights and related rights, which then could become problematic for the availability of COVID-19 vaccines? Well, here's a picture of the signing ceremony. This is from April 1994. And it's the signing ceremony which ensured that the WTO, the World Trade Organization, agreement on TRIPS came into force. And immediately, it meant that developing countries, which had previously excluded from patentability pharmaceutical product inventions, and India did this, Brazil did this, many other middle income and low income developing countries had said, in the public interest, we will refuse to grant patents on pharmaceutical products. Well, of course, in the 1990s, we had a pandemic. It was the HIV/AIDS pandemic. So very soon after the signing of the TRIPS agreement and the obligation that developing countries would now have to, in accordance with Article 27 of the TRIPS agreement, grant patents for pharmaceutical product inventions, the attention focused on something that we now call TRIPS flexibilities, that there are possibilities which are safeguards in the WTO agreement, which say that a country can take emergency measures and set aside patent rights in the public interest. And foremost among these safeguards is something called compulsory licensing, which is particularly useful when a country can designate a national emergency and give a local manufacturer the ability to manufacture, for example, a drug product without this constituting a patent infringement, without getting the authorization of the right holder. And as of January 2017, there was an amendment to the TRIPS agreement, which actually said even a rich developed country can designate a national emergency which is taking place in another country and manufacture under this so-called compulsory license for export. And in fact, this happened once when Canada exported drugs for HIV/AIDS and exported them under a compulsory license to Rwanda. So a cheaper, what we call a generic version, a copy of the patented medicine without the patent owner's consent. Well, the problem with the COVID-19 pandemic is that these compulsory licensing amendments have not proved to be a solution to the lack of vaccines available during the pandemic. So if we fast forward to the pandemic, and we'll start to look at why this has not been a sufficient solution. The pandemic has raised controversies about whether companies like BioNTech, Pfizer, and AstraZeneca and Moderna are making unreasonable profits because, of course, they're applying for and presumably will be granted. There's always a time delay. Usually a patent is granted 3 years after you apply to the patent examiners for patent office for this. So soon we will start to see patents being granted, but companies are already worried that they would infringe if they started to manufacture, even on what is called a patent pending, so a patent which has not yet been granted. And this is the reason why in October 2020, a proposal was made to the WTO by the delegations of India and South Africa to the World Trade Organization that because the compulsory license system is not an effective mechanism to ensure access to vaccines and other healthcare technologies like ventilators or treatments or PCR or antigen tests, all these things are protected by patents and other IP rights, that countries should be allowed at national level to decide that they will not enforce these IP rights on COVID-19 related healthcare technologies during the pandemic. So this is the proposal that today is being negotiated at the WTO. So keep an eye on social media later and watch out to see whether an agreement is reached and whether then this is criticized as being, too weak to solve the problem, because at the moment we know that the United Kingdom and Switzerland in particular are trying to water down the impact of this. But the United States supports this, and this was a really big surprise that on the 5th of May last year, the United States Trade Representative, Ambassador Catherine Tai, she tweeted this press release to say that the United States supported the approach of India and South Africa to call for this so-called waiver of the TRIPS obligations for COVID-19 vaccines. It was interesting because the US is only supporting the waiver of IP on the vaccines, whereas India and South Africa and their supporters, about 80 countries are supporting them at the WTO, are calling for a much more general waiver on the other types of technologies that I described, like COVID-19 tests, antigen tests, and diagnostics and treatments, as well as the vaccines themselves. So you can see how the negotiations start to get tricky depending on what you consider to be the essential healthcare technology. Now, the day after the United States Trade Representative tweeted the support for the waiver on the vaccines, the Chief Executive Officer of Moderna gave an interview on the 6th of May last year, saying, and almost like boasting and saying, anyone trying to reproduce Moderna's vaccines will have to figure out how to make the messenger RNA, the mRNA, which is, of course, at the heart of the vaccine, and that they haven't told you how to make the vaccine in the patents. And that's weird, because the whole point of the patent system is that you are granted protection afforded by the patent for 20 years from the filing date, typically. And in return, you have to tell someone who is skilled in the art how to make your invention. So at the end of the patent term, they can go away and make their own version. And similarly, if there's a compulsory license or the patents are waived, you should be able to read the set of instructions in the patent document and make the thing. So it's very odd that he's saying you still want to be able to do that, even if you read the patent document. Around the same time, on the 4th of June last year, the European Union delegation to the World Trade Organization proposed a different approach, and I've highlighted in yellow on the next slide what the EU approach was. So instead of supporting the India-South Africa proposal in the way that the United States have done, the EU proposal called on governments to use compulsory licensing within the existing TRIPS agreement, which already provides this type of flexibility when there is a national health emergency. But as we've just seen, there are reasons why the compulsory licensing system won't work. And part of that is that companies who are making the vaccines and applying for patents are not disclosing enough information. So it's an insufficient legal mechanism. A compulsory license only gives you access to the patented technology, whereas the chief executive of Moderna was saying, we are basically using trade secrets and know-how, plus we have all the clinical trials data, which is kept secret to prove that the drug works safely and effectively. And we're not going to give you access to any of that because the compulsory license or waiver will only be on the patents. And in fact, the Central American, the Latin American country of Bolivia actually tried to use the compulsory license system in May of last year and found that no country wanted to give compulsory license on the vaccine technology to manufacture and to export and help the Bolivian population. And the reason is, of course, that countries were instead engaged in what became known as vaccine nationalism, trying to keep the vaccines for themselves rather than sharing with other countries. So that's another reason why, because the vaccine manufacturers are all working at total capacity, it's been difficult to get countries to help each other through the intended compulsory licensing flexibilities of the TRIPS agreement. So I'm coming to the end of my talk now. I think I've got 3 more slides after this, and I'll go through those quickly. In February of this year, I published an article online. It's free to download if you're interested in today's topic. And it's since then, in April, was published in a journal called the European Intellectual Property Review. And in the journal article, I go through some of the analysis that I've shown you today about the problems that have occurred during the pandemic and lessons that the European patent system perhaps could learn. And as you will probably know, in Europe, we have a regional IP office. It's called the EPO, European Patent Office, and the examining division to look at patent applications is based in Munich in Germany. So in my journal article, I look at 3 articles in the European Patent Convention. The first of these is on the publication of European patents. And basically what it says in Article 93 of the European Patent Convention is that when an applicant applies for a European patent, for example, on the COVID-19 vaccines, the EPO will publish this application, including a description about how the invention works, on its website 18 months after the patent application is filed. In my article, I say, why do we have to wait for 18 months? Because this is causing a lot of doubt and confusion during the current pandemic, because we don't yet know what patent applications have been made. All this information is kept confidential and secret. So in my article, I suggest early publication of patent applications might remove uncertainties about whether in future patent infringement would occur if a country were to manufacture the vaccine without authorization, and also would help countries to negotiate licenses, because often the way you commercialize your patent is to sign licensing agreements in different countries. And actually this might be helpful if people already know in advance what patent applications are likely to lead to patents granted in the future. So that was my number one proposal: early publication of patent applications. The second thing which I recommend is improving the disclosure requirement, Article 83 of the European Patent Convention. That's to say, returning to the point about the Moderna chief executive saying, even if you had a compulsory license or waived our IP, you still wouldn't know how to make the invention because we haven't told you how to do that in our patent application. But actually, under Article 83 of the TRIPS agreement, you must do this. You must disclose to a person skilled in the art how to repeat the inventive concept. So I proposed something called raising the bar, so raising the standard of that an applicant has to meet in terms of the information that they disclose when they tell how to make the invention. You must prove that the invention will work if you follow the instructions written in the patent document. And my third proposal is the most radical, and I'm not sure that I even support this, but I'll explain what it is, okay? So I know we've got students online from India. So in India, there is a provision in Section 66 of the Indian Patents Act, which states that a patent which has already been granted by the Indian Patent Office can later be revoked by the courts in India on grounds that the enjoyment of those patent rights is contrary to the public interest. And there are already 3 examples from past jurisprudence where the Indian courts have actually said, yeah, the existence of this patent limits the access and the number of companies that can manufacture the product. Sometimes these are agrochemical products, sometimes they are drug products. So we are going to take away that patent right forever. We'll permanently revoke this because it's against the public interest. Now that's the Indian law. Now in the European Patent Convention in Article 138, we don't have such a radical solution. A patent can only be revoked if the court decides that actually it doesn't meet the standard of we would expect that the invention is new, it has inventive step, and is capable of being used in a practical way and gives a full and sufficient disclosure of how to work the invention. We don't have this public interest grounds for revocation that exists in India. So I point out that this does exist in other jurisdictions and that perhaps in the future, the European Patent Convention should consider this and my other proposals as we prepare for the next pandemic. So very much now the debate is about pandemic preparedness. We knew this pandemic was coming. We haven't had a pandemic since 1919, but there will be others. We hope that they won't be worse than the COVID-19 pandemic. But in any case, the patent systems around the world must be ready for the next pandemic. So thank you for listening. I will stop sharing my screen and hand back to Charlotte.
Lovely, thank you, Duncan. That was really interesting and not something that I'd thought about, obviously from a marketing background. So although we do touch on IP and marketing, yeah. So really good. I've put into the chat, if anyone has any questions on the topic, please ask away. There's not been any while you've been talking, which I'm sure is because they're so engaged in what you're saying rather than being distracted in the chat. There was a couple of questions just from actually the beginning few slides that you presented, Duncan. So someone has asked about the QMI PRI. That's right, isn't it? The acronym.
Yeah, we're never sure how to say it. Some of my colleagues say QMIPRI, some say QMIPRI, some say QMPRI. So whatever you're comfortable with.
There's enough acronyms as there
yeah.
it could be in Queen Mary. So someone's asked about if are LLM candidates pursuing the IPR specialisation allowed to join and work on initiatives in the research institution?
Yes, I can answer that it's anonymous, so I don't know who asked that. So if I just go back to the Institute's website again, share this with the participants, there you are. So for example, last week we had an amazing 2-day conference, not in our CCLS building, but in the Honourable Society of Lincoln's Inn. And we had a 2-day program, an amazing conference program. I show you, we had topics like artificial intelligence, human genome editing, film and fashion, etc. And the reason that I'm showing you this is because this 2-day conference was free for our LLM students. And it was amazing to see our students there. And in the closing ceremony, I actually gave quite an emotional speech, and I said, you know, if you've been inspired by this conference, that's really important, and that's the most valuable thing, because the students you are the next generation of IP practitioners, IP lawyers. So if you've been inspired by hearing about artificial intelligence or types of issues I've been talking about today, then that's what makes it valuable. And now another example to answer this question, if I can find it, we basically had an amazing program. Well, no, I'll show you something different instead. We had an amazing project at Queen Mary. This is an article from today's Financial Times, okay? So a former LLM student of mine, who then became my PhD student, and now she is like an associate professor at another university in London. This is from today's Financial Times, and it's a profile of my student. She's from Ukraine. This is her name's Olga. And if I scroll down the article, she's making some proposals about the problems that there are with accessing medicines during the war in Ukraine at the moment. But it also says that she was helping to run a project in CCLS, which was to establish a specialized IP court in Ukraine. And this was a big 3-year project, and we had money from the UK government, and we had LLM students working on this project. And what the LLM students were doing was that they were preparing country-specific reports to say, in Germany or in the United States or other countries, this is how specialized IP courts work at present, and what principles of best practice can we take when we propose an IP court in Ukraine. So that's a success story of an LLM student who now has a profile in today's Financial Times, and started off working on some of our projects in the Institute. So back to you, Charlotte.
Fabulous. The other just couple of questions you have are both module related, so I'll answer Charlotte's question first, because it's quite a quick one. So Charlotte's asked, when do you select your modules? So you would normally select your modules during the welcome week when you start an induction, so that would be when you start with us in September.
Yeah, and I'll just add to that, Charlotte, that we help you, or we try and help you. Hope it doesn't make it more confusing, because during the Welcome Week, I think myself and all my colleagues, I think we spoke at 3 or 4 different welcome events to different groups of students just for the IP specialism, in which all the academics sort of basically did what I did and say, look, this is what I teach on this module. This is how we teach it. We have small group, discussions plus lectures, etc. And then sometimes the students then get more confused because they think, oh, this sounds more interesting than I thought. So my original plan is now changing. So the only problem is that it can sound too interesting, and you're challenged about what to choose. Yeah.
And I think actually the question that Mansha has put in the Q&A is about what actually links with that, Duncan. So she said that, is there a minimum number of modules that you can choose in one semester, if you like one over the other?
There is, and it's a good question, Mansha. The problem is I can't remember what the minimum number is. So you'd have to check with the, Charlotte can help, maybe direct it to Charlotte's colleagues.
Of course.
But yeah, it's a really good question, because otherwise, we could have students who are just hanging about doing no modules in semester 1 and then realize that they have too much work in semester 2. So there is a minimum number, but because I'm not involved in that side of the program, I couldn't tell you what that number is. Yeah.
That's still helpful, I'm sure. I know from a previous session that a similar question has been asked, and someone said a similar thing, that obviously we don't want to have you waiting around in semester A and not have anything to do, but also just for you in terms of managing your time, it's better to have the modules spread out so that you're not overly pressured with modules in semester B, for example, and then have a really quiet time in semester A. So also kind of study time too.
And I think I'm just reading now Mansha's question, and refers specifically to being interested in modules in semester C. That's okay, because as I explained, all the modules in semester C are 15 credits, so they don't take up too much of your total of 180. So as long as you do that minimum, but also keep in mind that some of the modules in semesters A and semester B, they're designed to give you that solid foundation in the principles of IP law, so that when you do those specialized modules in things like fashion and film or animal law, you already know about the IP. So there's also a logic for taking the earlier modules so that you're ready for the specialists learning in semester C. The other thing I'll say is that I'm impressed that no one asked me about the assessments yet, because basically we have the different modules have different types of assessments. So some of them are like an exam, some of them are like essay assessment, and some of them are even like group work and projects. So it's worth checking in the handbook, because we deliberately have a mix of different style of assessment, because different students perform better and enjoy different types of assessment. Basically there is a deadline for, if it's like a written assessment, like an essay, which I think is probably the most common way that we assess for the LLM. For semester A, there's a deadline in January to submit. And for semester B, there is a deadline in May. I'm marking 150 assessments at the moment, which they're good. I'm enjoying reading them. And then there'll be another deadline for semester 3. So we kind of space out the assessment deadlines, so you're not under too much pressure doing everything at the last minute. Plus, you get the written feedback on your assessment, so you can actually improve. And that's one of the best things that I like to see, is that I give students feedback from first semester, and they take that advice, and then the next assessment's better, which is fantastic for the professors to see.
Okay, thank you. Just a couple more questions we've had. So We've had a question about induction week. You will get information about that over the next couple of months. So welcome week and induction is used usually during September, and you'll get information on that if you've accepted your place by then, and you'll be able to see all the information and events that's happening, book yourself onto that. So look out in your inbox for that.
Can I answer the questions in the Q&A, Charlotte?
Of course, go ahead.
Okay, so I'll deal with the last one first, because it's about the dissertation. So as I explained, and I think Yashna probably understands already, it's not compulsory to take a dissertation in this specialism. I think about, to be honest, I think about 70% of the students do take a dissertation, but it's entirely up to you. Some students prefer to have on their CV, you know, all this expertise in different modules. And some of them want to do like in-depth research project. So to answer the question, what semester do we take up the dissertation? You having like an induction week, like specified that you are going to take the dissertation, then at the date around the middle of November, you need to submit a title and an abstract for your proposed dissertation. You are then allocated a professor as your supervisor. Then in January, you have your first meeting with your supervisor and you work out a plan for the dissertation in January. Then you usually have like the second meeting, maybe in May or June, where you report on how is the research going? Did you find the information you needed? And then a third supervision meeting, usually maybe in June or July, to discuss the findings and the conclusions and the recommendations that you'll make in the dissertation. And then the dissertation is submitted at a date, which is usually maybe the second week in August in the year that you finish your studies. So that's basically how it works. From November and then January, you start working and meeting with your supervisor. Oh, and there's another question about money. Good question, Anonymous. Yeah, the example that I used about the Ukraine court project, yes, the students were paid for research assistance. So we don't expect students to work for free. But it depends on, it's not like we have positions available all the time. It depends on, you know, when we get requests like from UK government to undertake a study, then we identify research assistants. And by the way, we always advertise that through the emails. So it's very like fair and open application procedure. So we don't just choose like cherry pick a student. There's always an opportunity for all students who are interested to apply for these positions.
Thank you, Duncan. That's great. I think we've just got one more question, which is from Charlotte in the chat, just saying if part-time students have the same level of access to extracurricular like Q Legal. As far as I'm aware, yes. There's no reason why if you're a part-time student you can't access these programs and still take part. Just because you're doing it over 2 years doesn't mean that you get less access to extracurricular stuff. So please don't worry about that.
Yeah, I'd second that, Charlotte, that part-time students are not in any way disadvantaged in learning activities or in the extracurricular activities. And, you know, and sometimes it's very nice to have part-time students because they have work experience, etc. as well. So, you know, it's useful to have these skills available to us.
Lovely. Thank you.
And the other questions from the chat, Charlotte, have we dealt with those?
Yes, we've done those ones. So
I don't know when induction week is, but
whenever
the term dates are, it will be the 2 weeks before the term starts. So whenever we start before that.
Don't worry, we're all covered there. Okay, so I think I'll probably wrap it up there if that's okay. If you've got, I think there's one more question in the Q&A, which is that's quite specific. So I may ask you if you get in touch directly, if that's okay. I'll just send you my email address on there and you're welcome to get in touch directly. I'm just conscious of time. So I'll send you that there.
Yeah. Oh yeah, this is the question which has just been deleted about the how long do you have to write your essays?
Yes.
It's actually it's longer than a month. I mean, I can tell you what I do. I give the students like a list of 5 or 6 essay topics in the first week of the semester, so that when you're attending the classes, you've already got in your mind, okay, this is useful point because I could include this in my essay. And then the essay deadline, as I indicated, is sort of after the end of that semester. So in my example, you would have more than 12 weeks because you'd know what the essay titles are before you start the module. The module is 11 weeks, and then you would have maybe another like few weeks after that to submit. So it's not like a short-term deadline like a month that was suggested. Yeah.
Thank you, Duncan. And that's the last question, so we'll wrap up here. So thank you everyone for joining today. Duncan, thank you very much for your time and the informative taster lecture. If anyone has any questions, please feel free to get in touch. There is a number of taster lectures taking place throughout June, so please keep an eye on our website and on an eye on your inbox, as I'm sure you'll get more sessions coming through that you can book onto. So thank you very much, and thank you everyone for your thanks in the chat just now. I will send a recording out of this session, so if you want to catch up on it, you can or watch again, or have an information, you can engage there as well. So thank you everyone, have a lovely day, and we hope to see you in September. Thank you everyone, bye bye.